Reyes is one of our seminal cases at the end of the state's case, and this only affects Officer O'Neill, really, with regards to the end of the state's case, and certain counts with regards to Captain Ascolese. Pursuant to State v. Reyes 50 NJ 454, specifically pages 458 and 459, 1967 case. The broad test for determination of such an application is whether the evidence at this point is sufficient to warrant a conviction of the charges involved. It cites Rule 3:7-6. More specifically, the question for the trial judge must determine is whether viewing the state's evidence, and only the state's evidence, in its entirety, be that evidence direct or circumstantial, and giving the state the benefit of all its favorable testimony as well as all the favorable inferences which reasonably could be drawn therefrom. A reasonable jury or finder of fact could find guilt of a charge beyond a reasonable doubt. There is to be no consideration be given to the evidence of inferences from the defendant's case, citing State v. Ferrelio at 36 New Jersey 80, a 1961 case. Official misconduct with regards to the law. A public servant is guilty of official misconduct when, with purpose to obtain a benefit for himself or another, or to injure or deprive another of a benefit, he commits the act relating to his office by constituting an unauthorized exercise of his official functions, knowing that such act is unauthorized, or he is committing such act in an unauthorized manner, or he knowingly refrains from performing a duty which is imposed upon him by law or is clearly inherent in the nature of his office. Official misconduct is a crime of the second degree if the benefit obtained or sought to be obtained or of another is to deprive or sought to be deprived is of a value of $200 or less. The official misconduct is of a third degree. In this case, it's of a second degree. Now, with regards to the official misconduct, we have State versus Grimes, 235 New Jersey 75, specifically pages 89 and 90 in the Appellate Division decision 1989. In order fairly to expose a public officer to prosecution for committing an unauthorized act, there must be an available body of knowledge, by which the officer had the chance to regulate his conduct. The law must give a person of ordinary intelligence fair warning what conduct is prescribed, so that he may act accordingly. That's citing also State versus Moretti, 52 New Jersey 182, a 1968 Supreme Court case. In that case, the defendant knowingly acted either as a public officer or as a private person, depending on which version of the state's case the jury preferred. He knowingly overcharged the public work or knowingly solicited inappropriate private work, again, depending on which version of the state's case the jury preferred. Ignored in the state's case was the amorphous area of private work which was to traditionally fall into constables, which was recognized by Bayless, Gargano, Kalin, and Thiefall, and New Jersey practice without apparent condemnation, and which has not been effectively confronted by recent efforts to modernize the office of constable. That's the case that I'm citing in State v. Grimes. The charges of theft by deception pursuant to our statute 2C20-4. A person is guilty of theft if he purposely obtains property of another by deception. A person deceives if he purposely creates or reinforces a false impression. The term deceive does not, however, include falsity as to matters having no pecuniary significance or puffing or exaggeration by statements, unlike to deceive ordinary persons in the group addressed. Tampering with records to destroy, remove, or conceal records. In this case, it's falsifying or tampering with records pursuant to our statute 2C 21-4A. Pattern of official misconduct pursuant to our statute 2C:30-7A. Crime of pattern of official misconduct. A person commits the crime of a pattern of official misconduct if he commits two or more acts that violate the provisions of our statute 2C:30-2. Conspiracy statute is 2C:5-2A1 as well as 2C:5-2. The definition of conspiracy: a person is guilty of a conspiracy with another person or persons to commit a crime if with the purpose of promoting or facilitating its crime he agrees with such other person or persons that they or one or more of them will engage in conduct which constitutes such crime, or an attempt or solicitation to commit such a crime. Or 2, agrees to aid such other person or persons in planning or commission of such crime, or of an attempt or solicitation to commit such crime. The state's case here at bar asserts that the defendant, Officer O'Neill, got paid for 2 off-duty employment shifts without working them, with the approval of defendants Ascolese and Chesler. It is their position that O'Neill was given these 2 show shifts by his superiors to repay, 2 no-show shifts, by his superiors to repay him for paying the damage of a civilian's car caused by a police vehicle. There are signed vouchers that show that the defendant was paid for these shifts. All of the charges against these defendants in regards to this motion are attributable to this alleged scheme. The following are the findings of fact that this court heard. With regards to the dates at issue, with regard as to this directed verdict for the defendants O'Neill as well as Captain Ascolese, they deal with 2 dates, June 3rd, 2014 and June 6th, 2014. On June 3rd, 2014, the location at issue is SIP and 1 and 9. It involves the afternoon shift from 3 to 7 p.m. The Department of Transportation, also I may be referring to that as the DOT, Skyway detail of off-duty employment, which also has been referred to as an off-duty job or off-duty detail. All means the same thing. On that date, Lieutenant Brown, who is now Captain Brown, supervised that afternoon detail DOT Skyway location on SIP and 1 and 9 post. That was a 2-officer post location. This location has testified by Officer Bode, one of the officers assigned to that post, was a quote-unquote very busy location where there was a 4-lane highway intersecting with 6th Avenue. He described that as a T intersection. There's a bagel shop on one corner, a wholesale car dealership on another, and a gas station across the street of 1 and 9. 1 and 9 is a 4-lane highway, as he described it to the court. Lieutenant Brown testified, and I find him to be credible. He's now a captain with the Jersey City Police Department. He's been with the force for 25 years. He was the supervisor for the afternoon shift of June 3rd, 2014. His patrol log, or also known as the supervisor activity sheet, where he went to each post listed on his patrol sheet. That was the order it took. He explained his routine as a supervisor for this DOT detail. He has no independent recollection of the June 3rd, 2014 and relied on his paperwork. He testified that the patrol log is his best recollection of who he booked on each post. Booked means that he checked in that particular officer for that day. However, he never listed all the posts he went to. He didn't write down the posts that were unmanned, such as the example that he testified to as to the Hudson Mall jug handle. As to the location at issue in this case, SIP and 1 and 9, he had no recollection of seeing Police Officer Bove or Officer O'Neill. Relying on his patrol log, he's able to testify that Police Officer Bove was at his post, SIP 1 and 9, at 16:20 hours. He did not log in Officer O'Neill. He doesn't recall Captain Ascolese contacting him about a detail for Officer O'Neill. It's clear to this court that there were no SOPs, standard operating procedures, no rules or regulations, or written procedures as to what to do on this detail, as corroborated by every other supervisor who testified, including Lieutenant Donnelly. He explained, Lieutenant Brown explained, that the master list roster, master list also known as the roster, is continuously being updated. How his patrol log is accurate over the pay vouchers. Yet, during cross-examination, after it was shown that he signed vouchers of officers not assigned to him, or on the days he didn't work, the DOT details. Sometimes he would say it's his patrol log, sometimes he would say his pay voucher. He testified how, as a supervisor, he could reassign officers to different posts if he saw a need to do so, that the priority was traffic or moving the traffic, not the paperwork. This was after cross-examination showed him that he had some anomalies. Now, what do anomalies mean? The definition of anomalies means something deviates from the standard, from the normal or the expected. So, it was shown to him certain anomalies in his paperwork on different days at issue. Officer Bove also testified, and he testified credibly. His testimony goes to the date of, again, June 3rd, 2014. His testimony is based on his paperwork, his voucher, S8H. He recalls the intersection of SIP and 1 and 9, as well as the intersection of Duncan and 1 and 9, as he got those two confused. His recollection were that both intersections were very busy intersections, as he described to this court. He testified that he does not have an independent recollection of the June 3rd, 2014 date. He does not know who he worked with on that day. He does not know what he did as to where he specifically stood on that day. Officer Bove's recollection is based on his pay voucher, his paperwork, and how it's correct as he testified. He says he was there on that day that he posted directing traffic. He testified on direct that he now knows O'Neill, which implies, at least to this court, because nothing else was solicited, that back in 2014, he did not know him before, or this court has no testimony as to whether he knew him in 2014. All I have is that how he testified he knows O'Neill now in 2018. That's what that means. He testified as to his procedure, how he worked the DOT Skyway detail numerous times. He filled out his voucher, waited for the supervisor to sign it and turn it in. On June 3rd, 2014, pay voucher was filled out and supervisor signed it. That was the Supervisor Brown, and he signed it in the foreman section of the voucher. Note, there was no procedure that existed as to where the supervisor signs these off-duty employment pay vouchers. Some sign it at the foreman's signature line, some sign it on the bottom of the form in the notes section. During cross-examination, clearly Officer Bove failed to follow his own protocol in having his off-duty employment voucher for the DOT Skyway project signed by the supervisor on at least 2 occasions. He explained how he may have missed the supervisor that drove by that post that day because it's a very busy intersection. The second day in question that involves this directed verdict is June 6, 2014. The location with respect to that date is Broadway and 1 and 9. Lieutenant Neil Donnelly, now a deputy chief, he testified, and this court finds his testimony to also be credible. As a supervisor, he used a patrol car because he was mobile. He worked as a supervisor for the June 6, 2014 morning shift, that's the 6 to 10 a.m. shift. He testified that most officers use their own personal cars to get to their posts. He went out to each post only once that day and signed the officers' pay vouchers. He signed on the foreman authorized agent signature line as well. He followed his patrol log as to what post he arrived at first, second, and third, and so on. He listed the time on his patrol log. When he arrived at a post, he expected the officer to be on the corner, as he testified to. He knows all the defendants. He testified that he has no independent recollection of the June 6, 2014 date, that he would rely on his paperwork as that occurred. He would rely on his paperwork as to what occurred on a specific date and who he booked, paperwork being his patrol log. Thus, his recollection and testimony is solely based on his paperwork. There was testimony of what has been caused Carmageddon, as the defense has described, referred to this DOT Skyway closure as it was a DOT, a big project, Department of Transportation, a big project that would cause an enormous traffic in Jersey City, and the traffic created chaotic issues. He testified that as per his paperwork, again the patrol log, he did not see Officer O'Neill on June 6, 2014, not on Broadway 1 and 9, as O'Neill reported on his pay voucher for the June 6, 2014 morning 8 shift. Now, during cross-examination of Lieutenant Donnelly, in his September 30th, 2015 statement that he gave to the prosecutor's office, he stated that he may have seen Captain Ascolese move around on his detail. He testified that he definitely heard Captain Ascolese over the radio, which would be tape recorded and preserved, but we have no radio evidence in this trial. Lieutenant Donnelly testified that he used the radio, he would check visually, then he would check on the radio to see if anyone picked up a detail or to pass along information. He testified that he also moved officers from post to post, and that clearly Commander Ascolese could also redeploy, reposition officers to different posts if he so chose. He wasn't aware of the motorcycle squad being used in this project until D1 in evidence was presented to him. He realized he made a mistake in filling out his pay voucher. He wrote that he used a patrol car for 8 hours as opposed to the 4-hour DOT shift for the June 6, 2014 date. Then his testimony during cross-examination established a number of anomalies as to different dates. D35 on June 4, 2014, his pay voucher is patrol log regarding Officer Cartagena. D36, September 23, 2014, undocumented move to another post on his patrol log. D37, May 13, 2014, either a mistake or it was another move he failed to document. D38, May 30, 2014, his off-duty pay voucher had a mistake, no patrol log. D39, July 1, 2014, his patrol log had post 22 uncovered, but the pay voucher had indicated it was covered. He testified that we need to trust the pay voucher, not supervisor's patrol logs. D40, May 30, 2014, another supervisor signed his officer's PO, police officer Vila's pay vouchers as he had him listed on his patrol log. D41, May 30, 2014, Lieutenant Donnelly signed numerous 5 officers' pay vouchers who were not listed on his patrol log, but were listed on another officer's patrol log. That was Sergeant Quish's patrol log, but he could not have an explanation why he would sign another officer's pay voucher. D42, June 19, 2000, Lieutenant Chesler signed police officer Tanio's pay voucher, who was listed on Lieutenant Donnelly's patrol log and not hers, but no explanation as to that. D43, June 19, 2014, D44, October 7, 2014, D45, September 23, 2014, in addition to D46, D47, D48, D49, no times listed on his patrol logs on D50, D51, D52, D53, D54, just all included more mistakes. He signed officers' vouchers who were not in his assigned district. He saw them work and he signed their vouchers. That's what he testified to. Lieutenant Donnelly testified that the vouchers are the best recorded, reliable, because it means that the supervisor actually went out to the post and saw him there, at that location, on that date and time. As to Lieutenant Donnelly, it's clear that sometimes he relies on his patrol log as being most accurate, better than the pay voucher, except when he signed the pay vouchers as the supervisor. Also heard from the police officer Torrey, who testified as to the date in question of June 6, 2014, because he was located at that post. He does not have any independent recollection of the June 6, 2014 date, does not recall this day without using his paperwork, the pay voucher, having worked that day. No recollection whether Officer O'Neill worked with him that day either. I also have heard from numerous supervisors for this DOT Skyway project who testified credibly. That's Lieutenant Brown, Lieutenant Donnelly, as I've already mentioned, but Sergeant Majori, Captain Santiago, Sergeant Mara, and they all corroborated each other as to the following with respect to this DOT Skyway off-duty employment project. It was the first time the Pulaski Skyway was closed down, causing enormous traffic problems for Jersey City, and the DOT established this detail to alleviate the traffic problems. It was called Carmageddon, it was called a mess, it was called problematic. Number two, they all agreed there were no standard operating procedures. No procedures, no policies as to this off-duty employment detail, DOT Skyway project specifically, as to filling out the paperwork, that paperwork being patrol logs, pay vouchers, even the master list and roster. And who could move, who could be reassigned, redeployed, relocated, other officers, other posts. Number three, their priority was the traffic, not the paperwork. The purpose of the paperwork, it appears from their testimony, was for the officers to get paid. Number four, as supervisors, they could reassign posts as they pleased. Number five, one supervisor, as a matter of fact, created a one-man mobile post covering 3 posts. 6, all agreed that Captain Ascolese, as the commander of the DOT Skyway detail, could reassign posts as he pleased as well. Supervisors differed, and lastly, number 7, they all agree that supervisors differed as to what paperwork were the most accurate. Supervisor patrol logs, pay vouchers, master list. Some supervisors testified that their patrol log was more accurate than their pay vouchers. Other supervisors testified the opposite. The pay vouchers were more accurate. Clearly, the master list was not as accurate as either the pay voucher or this patrol log. As it was testified, this master list or roster is continuously updated. C1 in evidence. I'm going to read certain portions of it that this court found to be extremely relevant. Page 7 of 50. Question, was Captain Ascolese and Lieutenant Chesler later? This is C1. It's a court exhibit because it is a stipulation by the parties, only as to this motion, to be clear. Question, were Captain Ascolese and Lieutenant Chesler later unaware that the woman got an estimate? This is that car accident that had occurred that involved Ms. Durango. And this is a question from Sergeant Swartzward. Answer from Officer Rucco. This is a stipulation as to Officer Rucco. Answer, yes. Question, and that he was paying for it. Answer, that's how they repaid O'Neill, with the DOTs. Question, all right. Answer, like that's what I heard. I don't know if he worked the DOTs, so this is what I heard. So I mean, you probably could check if he worked them or not. Then I go to page 9 of 50, where an assistant prosecutor, Lancet, asked the question, what do you mean, what did you take? I'm going to give you 2 DOTs to me. Answer, to make up for the money he paid out of pocket because the DOT, I think, is like 150 for 4 hours. Detective Signorelli, questions. Was that made clear in the conversation that I'm going to give them to you? You're not going to have to show up type of deal, question mark? How did you know that, question mark? The answer from Officer Rucco is, well, they just told him, we're going to give you 2 DOTs to make up for the money that you paid out of pocket. So I mean, question, do you know if he didn't go to those DOT assignments? Answer from Officer Rucco is, I didn't follow him around. It's just, if he did or didn't, but I remember that's what they said to make it up for, This court's analysis of this case, I have to look at the favorable testimony and favorable inferences which reasonably can be drawn from Officer Rucco's statement. The difficulty that this court has is that the investigators, as well as the assistant prosecutor who was there, didn't follow up to clarify what Officer Rucco meant by, Investigators need to clarify, get specifics as to what he means by, especially when Officer Rucco is a police officer. That last answer, I didn't follow him around. It's just, it's, if he did or didn't, but I remember that's what they said to make it up for, The investigators needed to specifically ask Officer Rucco, I don't know why, or don't you tell me what you mean by, So, to be clear, the prosecutor wants me to infer that, quote unquote, meant that O'Neill would be repaid by giving him 2 DOT jobs, that he didn't have to show up and work, rather than giving O'Neill these 2 DOT jobs where he can bypass the big pick process as was described by numerous supervisors. You say that the benefit, prosecutor says that the benefit could not have been access to working these 2 DOT jobs, since these off-duty jobs were so easy to obtain. But the only reason the prosecutor is able to argue that to this court as to these off-duty DOT jobs were readily available post, he can argue that today in 2018. And the reason why he can argue that is because of the benefit of hindsight. At the time of June 2014, 3 months into this DOT Skyway detail, it was unknown how easy or difficult it would be for officers to fill these 52 or 55 police posts. They didn't know there would be so many open, unmanned posts. Therefore, without the benefit of hindsight, at the time, in June 2014, the logical inference is that Captain Ascolese provided O'Neill with 2 DOT jobs, Skyway posts, that he would work. Not to mention, he could assign him as a roaming or mobile officer for those 2 DOT Skyway districts. He could bypass the pick process as was described to this court. This court finds that Officer Rucco's testimony, as stipulated by the parties, does not provide the favorable testimony or favorable inference which can be reasonably drawn. Emphasis on reasonably. I'm left with the paperwork that is clearly not as accurate as purported to be. no one has an independent recollection as to those two dates of June 3rd and June 6, 2014, whether Officer O'Neill was present as a fixed post or a mobile post. The fact that an officer does not recall and that the supervisor for the district does not have him booked on his patrol log is of no consequence, because who booked the officer? Who booked Officer O'Neill was the commander of the DOT Skyway project, Captain Ascolese. And as such, all testimony was that he could, Captain Ascolese, he could redeploy, change officers as he saw fit, based on the traffic need, based on complaints from citizens, based on complaints from businesses, based on complaints from politicians, telling him they needed certain traffic to move or to be changed. June 3rd, 2014, Officer Bove didn't even know Officer O'Neill. Lieutenant Brown did, however, but the fact that his patrol log didn't book him, it's the pay voucher signed by the supervisor that booked him, as so many other supervisors testified to as well. So, there's no direct evidence that Officer O'Neill was not at the DOT Skyway post, which were these two-man posts on June 3rd and June 6th of 2014. Officer Bove even testified that he didn't even know Officer O'Neill and how busy that intersection was and how he could have missed him. Officer Bove on June 3rd, 2014, and Officer Torrey of June 6, 2014, both testified that they do not recall whether Officer O'Neill was with them at their specified posts those days. They had no independent recollection of any of the off-duty detail Skyway jobs they worked. They relied on their pay vouchers, and the off-duty detail pay vouchers do not have a line indicating what officers they worked with on that particular post. Frankly, I do not recall does not mean that an Officer O'Neill was not at his post. Third, both supervisors, Lieutenant Brown at the time, now Deputy Chief, on June 3rd, 2014 date, and Lieutenant Donnelly, I think he's now a captain, for the June 6, 2014 date, their respective testimony is that they did not see Officer O'Neill at that post. The one time they went out to their respective posts for the June 3rd and June 6th date. They had no independent recollection. They relied on their paperwork. Paperwork is the supervisor patrol logs, where they did not book or check Officer O'Neill in on those days. However, based on the state's evidence, Officer O'Neill was booked on those days by Captain Ascolese, the DOT Skyway commander of the project. How did Captain Ascolese book O'Neill? By signing Officer O'Neill's pay voucher for those 2 days. The state conceded that there were no SOPs, procedures, policies in place that prevented Captain Ascolese from booking O'Neill. As testified by both Supervisors Brown and Donnelly, pay vouchers are the most reliable to book an officer at his off-duty detail post. I note sometimes that they said or testified to that the patrol log was most reliable. They went back and forth. Again, as conceded by the state, there were no standard operating procedures, no policies in place to indicate what documents, supervisor's patrol log, pay voucher, master list, also known as the roster, which one is most reliable to book an officer at his off-duty detail post. No requirements except that pay vouchers had to be signed by a supervisor in order for that officer to be paid, as testified by Mr. Mahoney. But now we have to look at Officer Rucco's testimony as stipulated by the parties for this motion only. What is meant by you know, and I cannot make any other conclusion as I stated previously. In hindsight, we could believe that these off-duty detail jobs were easy to get. But in hindsight, as of 2018, 2014, there was no idea that so many posts would be readily available. So the fact that Officer Ascolese, strike that Captain Ascolese says Officer O'Neill was at his post those 2 days, as far as this court is concerned, based upon his pay vouchers and the signature of Captain Ascolese signing his pay vouchers, that's unrefuted testimony by way of the state's evidence. O'Neill's pay vouchers of June 3rd and June 6, 2014. All supervisors testified that Captain Ascolese could sign the pay vouchers, not only as a captain, but more importantly as a DOT Skyway commander. Again, no SOPs prohibiting from signing an officer's pay voucher. No SOPs prevented Captain Ascolese from assigning or reassigning an officer, such as Officer O'Neill, to a post, or create a roaming or mobile post, as other officers relocated officers from one post to another for traffic needs. No SOPs prevented Captain Ascolese to give 2 DOT jobs, or as Officer Rucco testified, to give O'Neill 2 DOT jobs to make up for his good deed of paying a citizen for damage to her car as a result of a patrol car hitting her. Captain Ascolese could bypass the PIC process, how this off-duty detail jobs were obtained. Again, no SOPs prohibited the commander from doing so. Captain Ascolese had 55 positions to fill throughout the city, and only 52 posts were filled according to the master list or roster. The 55 positions, this court finds, is based on the MOU that was submitted in evidence. O'Neill's pay voucher only listed one location, working on the dates in question. He didn't have to list all of the locations that he went to as a roaming mobile post. Again, no SOPs, no procedures, no policy prohibited O'Neill to only list one location on his pay voucher. Without the standard operating procedures, these SOPs, without policies for officers to follow as to the paperwork and to the job, pursuant to State v. Grimes as well, Officer O'Neill is acquitted on all counts that refer to him. That's counts 1, 4, 99, 100 through 104. As to Captain Ascolese, the counts that refer to him and Officer O'Neill, where they are combined, that's counts 1, 4, 94, 95, 96, and 97, for the same reasons as above. But additionally, it is clear to this court, as testified by Lieutenant Donnelly, who is now a deputy chief, and Lieutenant Brown, who is now a captain, that they as supervisors trusted their line officers in signing the officers' pay vouchers, and the commander, as the head of the entire DOT Skyway project, has the authority to sign an officer's pay voucher, as well as to trust his line officer that he worked that job. Therefore, he is acquitted as to those counts that involved Officer O'Neill. Lastly, I must say that I wanted to come back with this decision yesterday, and this court, Officer O'Neill apologizes to you for taking this one additional day it took to reach this decision that you had to undergo for the past 2 years of this ordeal to come to an end, at least to an end in criminal court. To explain to you, sir, by law, I had to look at all of the state's favorable testimony and unfavorable inferences that are reasonable. And in doing so, I had to go back through my copious notes from September when Lieutenant Donnelly testified as to the date referring to June 6, 2014. And that's why I had taken this one date. Thank you very much. Once I got, you have your witnesses ready for prosecution?
Judge, you're in the sidebar.
You want to go to the sidebar? Yes, welcome. Off the record or on the record?